Hello everyone, my name is Chiranthi Senanayake and I'm going to be actually conducting an online lecture on investigation which is part of the criminal procedure syllabus for the final year of Sri Lanka Law College. But before I go on to the lecture itself, I would like to first thank the Sri Lanka Law College student movement ProStudies, who is actually putting together online videos to help students who are sitting attorneys at law examinations at Sri Lanka Law College this year and in the coming years. I mean, it's an absolute pleasure to be a part of it. Before I go on to the particulars of investigation as an important section under criminal procedure, I want to actually talk a bit about what it is like to sort of study what I term procedure-based subjects and what it is like to face procedure-based examinations. Now, if you take a look at your journey at law college, at Sri Lanka Law College, we see that the first year, the preliminary year, is focused on giving you a foundation in law, to give you a grounding on the basics of law. Then second year focuses on more niche areas, more specific areas like property law, public international law, and even intellectual property law. And third year is more focused on actually understanding the systematic application of law itself. How really does law function practically, and what is the due procedure that is followed? That is why in your final year Sri Lanka Law College syllabus, attention is given to procedure and evidence more in comparison to other more theoretical subjects. So that is why we have 3 procedure-based exams, namely Civil Procedure 1, Civil Procedure 2, and Criminal Procedure. So Civil Procedure 1 and Civil Procedure 2 is based on the Civil Procedure Code, while Criminal Procedure is mainly based on the Code of Criminal Procedure. So as you can see, the gamut of the syllabus, or perhaps majority of the syllabus, is based on a particular code that's governing the procedure, right? So what we need to understand is that the purpose of these 3 papers is to analyze if a student who is facing these papers or sitting for these examinations has an adequate knowledge of due process, what really is the due process that is followed by the legal system and the legal structure of the country in terms of the particular type of law that we are studying. For example, if it is criminal law, in criminal procedure, we actually try and understand what really is the due process that is followed in terms of really applying the theoretical law that we learned in reality. So when you are really talking about sort of studying procedure-based subjects like civil procedure and criminal procedure, what is important to understand is that what the examiner really looks for is whether or not you actually understand the important sections of this particular code you're studying. And they want you to, after understanding, to interpret it, to sort of understand the main essence of it, and to express it in your own words. So one misconception that a lot of students have is the fact that procedure-based subjects are purely based on memory, as in it is just a matter of sort of remembering the sections and parroting it out in the paper. But that's really not the case, because you need to understand the core essence of the section before you actually state it in your answer, right? So the easiest way to actually study for procedure-based examinations is for you to sort of first run through the syllabus and then break it down into different chapters or sections. For example, if you take criminal procedure, you can break it down into investigation, into arrest, into bail. So there are different key areas under criminal procedure that you have to study. So what would be easiest is, once you break it down into these key areas, is to sort of run through the main provisions of the Criminal Procedure Code, or rather the correct way to refer to it is the Code of Criminal Procedure. So it's to sort of identify the main sections in that Code of Criminal Procedure that is relevant to that particular chapter. Now, if you take actually the chapter on investigations, we see that it has sections starting from section 21 and even ending with, let's say, section 180, right? So we see that throughout the entire code itself, there are sections that are applicable or that are relevant to the particular chapter that you are studying. So that is why it's important for you to break it down, break the code down itself into the chapters that you are studying. And also, now that I've sort of deliberated on how do you really make short notes, or rather how do you study for the criminal procedure paper or procedure-based papers, let's take a look at what really the examiner is expecting from an answer in a procedure-based examination. So what we need to understand is that there are two types of examinations in law. Firstly is a theory-based exam, and secondly is a procedure-based exam. So a theory-based exam is more or less about understanding a theoretical background of law, perhaps the theoretical content of law, interpreting it, and in most cases the questions would ask you to sort of state your opinion on that particular theory itself. I mean, the best example being jurisprudence. Jurisprudence is actually about the science of law. Law is a science. But it also requires you to interpret the theories in jurisprudence in your own, opinions or in your own thinking. So that's a theory-based exam. So it allows you to focus on your personal interpretation of law. Versus a procedure-based exam has a lot to do with understanding the law. Interpreting the law itself. In terms of what we mean by interpreting there is sort of understanding the main essence of the law. And then finally is to sort of write the law as you understand it in your own words. So it's not about providing an interpretation. It has everything to do with understanding the law and writing it in your own words, right? So when I was actually studying for procedure-based examinations, I made it a point to practice, as in I wrote answers, even though it was very last minute, I did actually write a couple of practice answers. And in these answers, I tried to achieve three things. The first thing is I tried to make sure that my answer was as accurate as possible, as in my answers were as close to the law as possible, because this is a procedure-based exam, not really a theory-based exam. And the second thing I tried to do is I actually tried to organize my answers. Now, this is actually key in a procedure-based exam. See, in a theory-based exam, you can actually approach the answer in any way. But when you are writing a procedure-based answer, what's important to understand is there is a particular flow of sections throughout the Code of Criminal Procedure. So, for example, if you're writing an answer on arrest, you have to start by first defining what arrest is as per the law of Sri Lanka. You can't, for example, start on the provisions of arrest in the Code of Criminal Procedure and then suddenly in the second paragraph or so say, by the way, arrest is defined in this particular way in the law, right? So that would make your answer look messy, and would also mean that the law is not logically, structured in your head. So that might actually cause you to lose marks. And the third thing that I always try to follow is I try to actually keep my procedure-based answers simple, right? Because sometimes when you sort of convolute your procedure-based answers, or perhaps answers to procedure-based examinations, what happens is when you try to convolute it or complex it or to explain it in a way that you think will impress the examiner, it sort of gives a misinterpretation of the law, and you don't want the examiner to think you don't really understand the due process or the due procedure of the area of law that you're studying, right? So this makes it, three aspects, which is to make it accurate, organized, and simple, makes it very easy to sort of answer, a procedure-based examination. Now that we've identified what really are procedure-based subjects and how do you really answer a procedure-based examination, let's take a look at the area of investigation, which is what we're really focusing on, right? Now, investigation is actually a very crucial aspect of criminal procedure. And why it's crucial is simply because when you take an offense of any kind, right, one important element of an offense is causation. The fact that the accused indeed was the person who actually caused the harm or the crime that has taken place. And in reality, when you are actually, in building a case, or perhaps when you are trying to figure out the facts and the figures of the case, investigation plays a key role. And there is quite a large number of sections that are dedicated in the Code of Criminal Procedure to investigation and due process that's followed in investigation itself, right? So there, as I said before, there are a couple of important set of sections. It starts with section 21 and also includes section 180. So what I've done is I've actually made like a short note about investigation, and what I will be doing is I will actually be reading out important sections from the Code of Criminal Procedure, which I've summarized in my short note, and I'll be sort of reading it out to you and then explaining as to why these sections are important and a few things that you need to remember when you are writing about investigation in your criminal procedure examinations. Please remember that all criminal procedure examinations have a question on investigation. I mean, up to this date, I've never seen a paper that does not have a question on investigation. Areas like arrest, investigation, bail are commonly asked questions. So I really hope that this lecture is actually helpful to you. So to start off with regards to investigation, what we first need to look at in terms of the process of investigation is information, right? Investigation, a process of investigation first starts with the relevant authorities receiving information that a particular crime has taken place. So one thing you need to first understand is we need to look at who really has the responsibility to give information under the law, who has the liability to give information to relevant authorities under the law about a crime or a potential crime that has actually taken place. So Section 21 of the Code of Criminal Procedure argues that the public as a whole actually has a liability to give information, right? So what that section says is every person aware of commission or intention of another to commit an offense under the Penal Code, any sudden or unnatural death, death by violence or suspicious nature, or if a person finds a body or dead body of a person being found without it being known how that person died. So there are 4 circumstances that is actually detailed out in Section 21 of the Code of Criminal Procedure, which creates a liability for the public to actually provide information to the relevant authorities. So the first one being if there is a commission of an offense or if you know that another person is intending to commit an offense. Then the second is where there is a sudden and unnatural death, like, there is a sudden death and it does not seem natural enough for it to be just a passing. And thirdly, where there is a death by violence, or there is a death of a suspicious nature. And fourthly is where there is a dead body that is found, unfortunately, and, we do not know, right, what really was the cause of the death. So in such a situation, without delay, the section highlights that without delay, that the public has a liability, right, to inform either the nearest magistrate court, the OIC of the nearest police station, the peace officer, we will actually later evaluate who a peace officer is, and thirdly, the Gram Sevaka Niladhari of your nearest village, right? So there are 4 people again, or 4 authorities again, nearest magistrate court, OIC of the nearest police station, your peace officer in the village, or the Gram Sevaka Niladhari of the village. Now the section highlights that when you are providing this information, it has to be with undue delay. And if there is a delay, you have to actually provide a reasonable justification as to why you as a member of the public was late in terms of providing this information. Right? So now we know that the public has a liability in terms of providing information which leads to an investigation. Now we move on to Section 22, which really is the responsibility of a peace officer, right? So a peace officer is actually an agent that is appointed by, the ministerial authorities that are overseeing law and justice. So what Section 22 says is in terms of a peace officer, it says that once a peace officer actually obtains information about the same 4 circumstances that was detailed in Section 21. Now, what are the circumstances? First being commission or intention to commit a crime. Second being a violent death which is very suspicious in nature, or a death that has occurred which seems unnatural, or the 4th circumstance being where a body is found and we do not know what the cause of death is. So in those 4 circumstances, if a peace officer gets information about any one of those 4 circumstances, the peace officer is also responsible or liable to actually report and communicate that information to 3 main parties without delay. The first being the nearest magistrate. Second being where any legal inquirer that is within his jurisdiction. And third being, his own immediate superior, the person who is more superior to the peace officer in the legal hierarchy of that area. So Section 22 says even a peace officer has a liability or a responsibility to actually provide the information he has received to those three parties, right? So now we know who really is liable to provide information or to the relevant authorities, which commences an investigation. Now, information that is provided by the public or is actually provided by a peace officer would constitute what we call first information. That is because that is the first information about the offense that the relevant authorities like the magistrate court or the police have received about that particular offense, right? That's the initial information received. So if you take a look at first information and the due process relevant to first information, there are a few sections that are very important for us to remember. The first section is section 109, and remember in section 109 there are subsections which deal out or perhaps clearly state how first information should be treated and should be recorded. So if you take a look at section 109(1), so where there it says every such information could be given to a police officer or inquirer either orally or in writing. So when a member of the public or the peace officer is providing the information to the police officer, that is usually the OIC of the nearest police station, it is very important that that person can actually provide that information either orally, that is as in verbally, or in writing, right? Now the police officer, the definition of who a police officer is provided in section 2 of the Code of Criminal Procedure. So I would actually like to deviate a bit and advise you that when you are writing your answers for the Code of Criminal Procedure examination, criminal procedure exam, it's important that you actually provide definitions that are provided in sections 2 of the code, because that allows you to sort of give a firm definitional foundation before you go into the due procedure itself, right? So if you take a look at how a police officer is defined in section 2, we see that a police officer is defined as a member of an established police force. Is actually defined as a police officer. So that's a very obvious definition that is provided. So, and what we see is that it can also be when you're talking about an inquirer. So you can actually give first information to either police officers or an inquirer, as stated in section 22. A peace officer can report to the inquirer of his area. An inquirer is actually defined in section 106 as someone who is appointed by the minister, just like the peace officer, and he has to be appointed by name or office for any area, and we see that the limits of which will be specified in the appointment, as in his jurisdiction also has to be specified in the particular appointment. For example, if it's an inquirer for Rajagiriya, in the appointment letter itself, his jurisdiction has to be stated as only applying to the area of Rajagiriya. So that is a simple example of who an inquirer is. So what we learned from section 109(1) is the fact that you can actually provide first information either orally or verbally to a police officer or an inquirer. Now let's look at section 109(2). Yes, in section 109(2) it stated, if information is given orally, it must be reduced to writing. So even though at inception information can be given orally, the inquirer or the police officer must reduce it to writing. If it is not possible for the police officer or inquirer to record the information in the language used by the informant, he may request the informant to give the information in writing. So in a situation where the police officer or the inquirer actually receives first information about an offense from a person who can't speak, let's say, in the language that the police officer or inquirer is speaking in. For example, if the police officer or inquirer is speaking in Sinhala and does not understand Tamil, but the person who is giving first information can only converse in Tamil. So in such a situation, the police officer or inquirer can request the other individual to provide his statement in writing rather than taking it orally. So if the informant is actually unable to give it in writing, here the law says, the police officer or inquirer shall record such information in one of the national languages and also record the reasons for doing so. Now, this may actually come in handy, in a situation where, let's say, the first information is provided by someone who does not speak either Sinhala or Tamil. So, in such a situation, the police officer will actually have to reduce what he is saying to the national languages and record it. Further, must read over the record to the informant or interpret in a language that he understands. Now, what is important here is that after the first information is reduced to writing, the police officer or inquirer must actually read it back to the person, the source of the information, the person providing the information, and ensure that the information is accurate. So it has to be provided, read back in a language he understands. So most probably what they would do is use an interpreter or a translator. Now, in this, when we are coming to this junction of understanding investigation, it's important to highlight a particular case called Panditaratna versus ASP of Kegol. So this particular case sets the precedent that first information can be given in writing, orally, or even via telephone. So Panditaratna versus ASP of Kegol actually interprets a law to say you can give it orally, you can give it in writing, and you can actually give it over the telephone. So for example, you can call the police station and provide the information. So that is in terms of 109.2. Let's look at section 109.3. So section 109.3 states, the information that is actually recorded has to be signed by the informant or the person, the source of the information, right? And also it has to be included in the information book that's maintained by the police station or the inquirer's office without unnecessary delay. As soon as possible, as soon as it is recorded, it has to be included in the information book. Now, what really is an information book? For this also there is a definition in section 2 of the code, which says that an information book is actually a record which includes a crime pad or a file, and it's maintained by the Criminal Investigation Division of that police station, the CID, and any Bureau of Investigation for the purposes of recording a statement. So the information book records statements about offences, and it is maintained as a crime pad or a file by the CID or a Bureau of Investigation. Now we've understood that in section 109.3, the informant has to sign the record itself. Let's move on to section 109.4. So in section 109.4, it is stated that if the police officer that receives the information is not the OIC, so remember in section 21 and 22, it states that you can report to the OIC, right? As you have to report to the OIC. If it is not the OIC himself, he shall report the facts of such information to the OIC. As in, if the police officer who actually takes the first information is not the OIC, if the OIC is unavailable, then the criminal procedure provides opportunity for that police officer to report the facts that he learned, the information he received, to the OIC of that particular police station. Now, here at this particular juncture, I want to highlight another case called King versus Publish. So the first case was Panditaratna versus ASP of Kegol. There we learned that first information can be provided verbally, in writing, or via the telephone. Next case is actually King versus Publis. So King versus Publis, the facts of the case in a nutshell is there were two females who were abducted by a group of men. And these two females were actually taken in two separate directions. They were abducted, they weren't taken together. So one female actually was raped, and the other female managed to get herself free, and both of them, they both managed to escape. And they arrived at the police station at two different times and provided record of the same offense, at two different times, right? So in that particular instance, right, the law says that both these statements are actually regarded as individual first information. Why that is because even though it is conducted by the same individuals, the act is prosecuted as two separate crimes because the victims are two separate victims, right? So that is why it was considered as first information. So if you get a question with regards to one accused actually conducting an act against two people, and if both of them come and report first information, they will be considered as two separate individual first information. So that's another important case that you can actually bear in mind. Right. So now we have actually looked at who has the liability or the responsibility to provide first information. We have now looked at also how do you record first information. Since we've dealt with those two stages of investigation, let's now look at commencement of investigation. As in, once you actually receive first information, how does investigation commence? So for this purpose, section 109.5 is absolutely crucial, right? So in section 109.5, it says, police must then consider whether it is an offence that needs to be investigated, because there are certain offences that do not require investigation under the law and certain offences that require investigation. So if the answer is affirmative, as in if investigation should be conducted, then an investigation is carried out by the police officer, right? The next issue is whether such an offence is a cognizable one. So firstly, the police officer and with the supervision of the OIC makes the decision to conduct an investigation. Once that decision is made, then you look at whether or not the offence is a cognizable offence. Now, this is actually a terminology that appears a lot in your criminal procedure exams. So let's take a look at what really is a cognizable offence. Now, a cognizable offence again is defined in section 2 of the Criminal Procedure Code. And it says that a peace officer may arrest without a warrant in accordance with the first schedule of the Act if an offence is cognizable. So a cognizable offence is one where a peace officer and a police officer has the right to arrest without a warrant for particular types of offences. So the first schedule actually gives quite a spectrum of offences that are listed in the penal code, right? And what is also important is any other cognizable offence shall be stated in such other law to be cognizable. So what they mean by that is, even if the first schedule does not identify all the cognizable offence, if another act recognizes a particular action as cognizable or a cognizable offence, then as per the Criminal Procedure Code, those acts are also considered to be cognizable offence, provided that it's identified as such in the law of Sri Lanka. Yes. So once the police officer or the peace officer identifies whether it is an act or offence that requires investigation, then what we do is, if from the information received OIC has reasons to believe the commission of a cognizable offence or apprehend a breach of the peace, he shall 1. Send a report of the same to the magistrate, shall proceed in person to the crime scene to investigate the facts and circumstances of the case. Thirdly, take measures as may be necessary for discovery and arrest of the offender. So once the information is processed by the OIC and the OIC has reason to believe that there has been a commission of a cognizable offence, then the OIC goes along 3 separate simultaneous actions. Firstly being, he sends a report of the record obtained and the first information obtained to the nearest magistrate court. Secondly, he will actually proceed in person to the crime scene to investigate and record the facts and circumstances of the case. And thirdly, what he or she will do is actually they will take measures as may be necessary to actually discover or identify the accused and to arrest that accused or the offender. Now, that is where a police officer or peace officer identifies the need for investigation, that particular offence itself should be investigated. Now, on the contrary, if it does not need to be investigated, then the police are actually not obliged to investigate in itself. So investigation as a legal obligation comes only in situations where the offences require investigation by the law. So that is also something that's important to remember. Next, we go on to really now since we're done with section 109, we go on to section 110, where we analyze how should really statements be recorded during the course of investigation. Just like there is procedure to record first information, there is also due procedure in terms of recording statements during the course of investigation, right? Now what we see is section 110 states, an officer may only examine any person acquainted with the facts and circumstances of the case. No oath or affirmation can be administered to that person. Now, when you actually arrest a person that is acquainted with, or not arrest rather, when you actually speak to a person that's acquainted with the facts and circumstances of the case, the police can't coerce or force that informant to take an oath and swear an oath when giving information, right? So this can be either a witness or a suspect. So it can be either the person who is suspected of committing the offense or a witness. This suspect can even be a future defendant, right? Even if it is a case where it's a future defendant, as in possibly it is someone who, let's say, is suspected of aiding and abetting the crime. Even someone like that, the police cannot force them to take an oath of, let's say, truth before providing the statement itself. Now let's look at section 110(1), subsection 1. Such statements must be recorded in writing. Just like in first information, it has to be reduced to writing. Must be recorded as if the officer asks questions in clarification and the answer is given for that. So when you are recording it, you cannot record it as one long statement. It has to be recorded as a question being posed to the informant, not the informant, rather the witness or the suspect. And then the police officer recording the statements is answers to the questions he or she is posing. Therefore recorded in the form of questions and answers, as I said before. The record shall be then shown or read to the person. So just like in first information, after you record it, you must read it back to the witness or the suspect. If he does not understand the language, it shall be interpreted to him in a language he or she understands. So it's very important that the person who actually provided the statement understands what has been written down. So this is to ensure that the statement is not distorted by the police officer or it's not inaccurately written down. So this is an element that is important in terms of due procedure. He is at liberty to expand or add to the statement at this stage. So once the police officer reads the statement to the witness or suspect, the witness or suspect can actually then amend or add to what he has already stated. The statement shall then be signed by that person. By that person meaning the witness or the suspect. He or she must sign the statement. The officer recording shall append below each statement recorded by him or her a certificate declaring that he has accurately recorded the statement. So the police officer, on the other hand, has to append, as in attach, a statement that says, I have accurately and truthfully recorded this particular statement, right? So that's due course in terms of recording statements during investigation. So let's take a look at section 110(2). Such person is bound to answer truly to all questions relating to such a case put to him by police officer or inquirer. So there is a responsibility on the part of the witness or the suspect to answer truthfully, and we will later learn that falsification of statements during the course of investigation is actually an offense under the Code of Criminal Procedure. So unless such a question would have the tendency of exposing such a person to criminal charge or penalty or forfeiture. So the person, the suspect or the witness has to answer truthfully unless the answer itself may expose him to a possible criminal charge, a penalty or forfeiture. For example, if the police officer directly asks you, was it you that has committed the crime? Of course, admissions, I think, are encouraged in the law because the law is merciful. However, you have the right to sort of refrain from answering that question because it may be later used to charge you or perhaps to, make you penally liable. Now, I spoke to you before about the falsification of statements during investigation and how that amounts to offense. So there are certain sections that relate to that. So section 177 of the Penal Code states, untrue statements will be considered an offense or will lead to an offense. If a person refuses to answer with a statement truthfully to a public statement, such person is legally bound to answer. Then he is bound to be liable to have committed a punishable offense. So what that section says is, 177 of the Penal Code says is, you need to answer statements truthfully, especially statements you are legally bound to answer. Like, for example, when a police officer or inquirer questions you about an offense, when you are legally bound to answer, you must answer truthfully. And if you do not answer truthfully, truthfully, you are bound or perhaps you are liable for an offense under the Penal Code under Section 180, which is falsifying a statement to a public officer. So Section 180 of the Penal Code says it is an offense to give a public servant information which the informant knows to be false. So please remember that when you are citing this in the paper, you can actually say that falsification of statements that you're legally bound to give results in, punishment and penalties. Yes. Okay. So that's in terms of falsification of information and how that results in a certain penalty. Now let's actually move on to really look at completing an investigation. So we have looked at the aspects of recording a statement during an investigation. So let's take a look at investigation and completing an investigation. Section 114 looks at investigation based on the facts of the case. Section 114 says, based on the facts of the investigation, it can be concluded that there is insufficient evidence to forward the suspect to the magistrate. So there may be situations where in the course of the investigation, the police officer or inquirer realizes that there isn't enough information to regard this person as a suspect and thereby forward the suspect to the magistrate. Such person must be released on him executing a bond with or without sureties, and he may be so directed to appear before a magistrate if and when required. So in a situation where there is a suspect, however, there isn't adequate information to link him to, let's say, the offense, but he is regarded as a suspect. In such a situation, the police officer can actually require the person to sign a bond with or without sureties, and require that person to sign a bond that says if he is required to appear before the magistrate court, he would actually do so. Right? This is because an officer may not conclude his investigation here. He will probably have to investigate further into the matter. So this is an instance where an officer may have to actually investigate further into the matter. So that's in terms of one aspect of Section 114, where the facts of the investigation does not give enough information or enough, let's say, prima facie evidence to believe that he or she is a suspect. So another thing, the second aspect that Section 114 deals with is where there is enough information to consider this person a suspect, right? In such a situation, the investigation has to be concluded within 24 hours. So the investigation is time bound. For example, you cannot actually conduct an investigation over a course of a week. You have to conduct an investigation within 24 hours. And once you identify that there is adequate or facts to sort of consider him or her to be a suspect, then you can produce that person before the magistrate court, the relevant magistrate court, and the police officer of that station can present the charges. It's usually the OIC. The OIC can actually present the charges and state that this person has been charged as a suspect with this particular offense or offences. So that's the second aspect of Section 114. Right. So those are two options that are actually available to a police officer or inquirer in terms of completing an investigation, which is one where there isn't enough information. You can get the suspect to sign a surety, like a bond without sureties, with or without sureties, and then request them to be present or require them to be present before a magistrate court if required. Then the second option is to actually look at presenting the suspect before magistrate court after concluding the investigation within 24 hours when there is adequate information, right? Now, the third option available is there may be instances where the investigation cannot be concluded within 24 hours. So that aspect of the law is dealt in Section 121, which says investigation should be completed without unnecessary delay. Magistrate should be kept informed of the progress of the investigation. So even if an investigation cannot, let's say, be completed within 24 hours as mandated, in exceptional circumstances, you cannot delay the investigation and the magistrate has to be informed. Then, so that's in terms of Section 121. I would like to deviate here a bit and look at two important sections, which is section 119 and section 115. So section 119 says it empowers a magistrate to withdraw the case under investigation from the inquirer and inquire the case himself and commit it to trial. So section 119 empowers the magistrate to actually take the case under his or her wing and to inquire the case by himself or herself and present it to trial. Now section 119 is important because under the Code of Criminal Procedure, you get questions with regards to the powers of a magistrate. So 119 can be quoted under the powers of a magistrate. Then section 115, when an investigation cannot be completed within 24 hours, as required by section, we looked at section 114, as required by section 114, and there are grounds to believe further investigation is necessary, right? Officer may forward the suspect to the magistrate. Officer may forward a report of the case, forward a summary of the statements made by each of the witnesses examined during the course of the investigation, produce any weapon or document or sample which has to be taken into custody. So where the police officer believes that the investigation cannot be completed, then he or she must provide the information that is so far in his or her possession, which is they can actually even forward the suspect to the magistrate while the investigation is going on. And the officer may forward a report of the case. He or she may produce any weapons, documents, or tangible evidence that has been collected. And they can also forward a summary of the statements that were recorded by the witnesses during the course of the investigation. Right? So if magistrate is of the opinion that suspect must remain in custody, he shall, that is, the magistrate shall, make such an order to say that the person has to remain within custody, however, must record reasons for doing so. So he has to justify why the person should remain in custody. Determine the period of such a remand. Normally, the maximum period is 15 days. You can, while the investigation is going on, you can keep a person under remand for a maximum of 15 days. At the end of those 15 days, if proceedings could not be instituted against the accused, he must be discharged. So there are reasons as to why the investigation cannot be completed within 24 hours. So section 115 says in such a circumstance, the police officer can actually present the suspect to the magistrate, and the magistrate can decide should that person be remanded, should the suspect be remanded. If he or she is remanded, then it will be for a maximum of 15 days. So that's in terms of the third option that is available. It is also important here to look at section 115 subsection 3, which again deliberates on this idea of not being able to, the circumstance of not being able to complete investigation within 24 hours. It says a magistrate shall not release on bail a suspect who has allegedly committed or is concerned in committing an offence punishable under section 114, which is waging, attempting, abetting, waging of war against the state. So that is actually an act of treason. This is 114 of the Penal Code, or 191 of the Penal Code, which is giving or fabricating false evidence with intent to procure conviction of a capital offence, right? So where they have fabricated evidence in terms of with the aim of creating a conviction against another for a capital offence, like for example murder. And section 296 of the Penal Code, which is murder. So in those three circumstances, a magistrate will not release any of the suspects remanded under bail. So bail is not provided to these particular offences, right? So finally, the final aspect I actually want to highlight in this very short video is section 115.4. which says upon an application, the police may have access to a suspect in lawful custody of a prison for the purpose of investigation. Right. So what section 115.4 says is once you remand a suspect, the police officers carrying out the investigation should have access to the suspect who is remanded, even though he is within the prison system or the remand system. Further, court may also permit the police officer to take the suspect from place to place for the purpose of investigation. So investigation does not only have to be carried out in the lockup or in the prison cell itself, right? And section 120, subsection 3, this is just an additional information which is not very important. After investigation, the B report and accused must be produced to the magistrate. So once investigation is completed, under section 120, subsection 3, this actually is what brings the entire investigation to a close. You have to provide the B report and the accused, and the accused and the B report has to be produced in front of the magistrate. So that brings us to a close of the process of investigation, starting from first information and ending with providing the B report and presenting the accused before the magistrate court. So there will definitely be a question about investigation, and most of the questions will ask you, it will give you a scenario and ask you whether the due process followed here is accurate, so that you can either agree with it as per the provisions that were discussed in this lecture, or you can disagree with it, as per the same. So that actually brings us an end to this lecture on investigation under the Code of Criminal Procedure of Sri Lanka. So I really wish everyone who is watching this video absolute success, and I really would like to wish you good luck for the final year attorney at law examinations. I know it's really stressful, and honestly the final year exams are perhaps the most stressful out of all 3 years, because there is so much for you to grasp and to absorb and to sort of rewrite in your own words in the paper. But just know that it's only a couple of months, and there at the end of the journey you are going to start a new life as a practitioner or an academic. So thank you so much.